In our last videos, we discussed some of the powers and duties of a conservator. In this video, we'll take a look at the various documents that a conservator over the respondent's property is required to file with the court. Additionally, unless the court explicitly waives the requirement of a bond in its written order, as a conservator, you are required to file your bond documents with the court. A bond is like an insurance policy that helps to protect the money and other property of the respondent. The court will tell you how much the bond needs to be set for in your case in its written order. The formula that is used to estimate the appropriate bond amount is the value of all of the respondent's assets, except for real estate, which is not included in the calculation of bond, plus all reasonably anticipated income for the year. For example, say the respondent owns about $58,600 in personal property. He receives $1,500 each month in Social Security, so for a year, that would be about $18,000 in Social Security. He also has a pension that pays the respondent $2,000 a month, in other words, $24,000 a year. Added up, it equals $100,600, so the court would likely set the bond amount at $100,600. Now remember how we just covered how real estate is not used in the bond calculation? While that's true, there's an important thing to keep in mind. If real estate is ever to be sold, the conservator must get permission from the court before selling it. Once the real estate is sold, the money received in the sale is added to the bond calculation formula and may affect the bond amount. It is also important to note that the court has the discretion in setting the bond. In some courts, the judge may decide it is in the best interest of the person with a disability to waive the bond on conservatorships in which the value of the property is under $10,000. There are additionally other factors in the law that the courts rely on when setting the bond. The time and service you spend helping an individual with a disability are invaluable. The person you are serving needs your help, your compassion, and your organized and responsible management of his money and other property. Make sure when you're making any decision as a conservator to always choose what is in the best interest of the person with the disability. Now remember, the information contained in this video is not intended to be legal advice and should not be relied upon as such. If you have any questions, or if you are unsure of your responsibilities as a conservator, make sure to talk with your attorney. Thank you so much for your service as a court-appointed conservator.
The Davidson County Probate Court Clerk's Office now has electronic filing, also known as e-filing. Therefore, you may file your annual status report and any other required documents, such as property management plans and accountings, by electronic filing, mail, hand delivery, or by fax. Keep in mind that fax filing requires an additional fee. To access electronic filing, you can visit the Probate Court Clerk's Office website at circuitclerk.nashville.gov and click on the link labeled e-file. There, you will be redirected to the Davidson County e-filing system. Thank you so much for your service as a court-appointed conservator.